you have 3 minutes open.
Well, first of all, I want to thank everybody very much for accommodating my trial schedule this week. I also want to thank you for the opportunity to be able to speak with you. It gives me an opportunity to tell you what I believe I bring to the table, essentially. First of all, I think it's important that an appellate judge have trial experience. You are reviewing perceived error, essentially, of the trial judges. And I believe it's important to understand that process. I am a board-certified civil trial lawyer, as you all know. I've served on the Board Certification Civil Trial Committee for 6 years until I termed out this past July. Served as both vice chair and chair beforehand. My practice, although I started at the state attorney's office, was primarily a civil trial practice, primarily practicing insurance defense, before I was elected to the bench in November of 2010. I served on the criminal bench approximately for a little over 3 years, handling serious felony crimes, until I was transferred to the civil bench earlier this year. And in Seminole County, it's different than some other counties, and where for civil, you handle essentially everything civil. We handle complex business litigation, mortgage foreclosures, personal injury malpractice, as well as family law litigation, so it runs the gamut. I have the unique position of both as a lawyer and a judge, handling both civil and criminal jury trials. Also, as a circuit judge, handled in the appellate capacity, both civil and criminal cases as well. I've been associate judge and had the pleasure of serving on the 5th DCA and writing an opinion, which was recently affirmed in June by the Florida Supreme Court, which Justice Kennedy wrote the opinion. I also believe it's important to work well with others in your relationships with your colleagues. I personally have a good camaraderie with my fellow members of the judiciary. Judicial philosophy is also, I believe, important. My personal philosophy is to essentially exercise judicial restraint. I think it's a judge's job to interpret the letter of the law, interpret the words, and to make sure that that law is being followed and to apply it accordingly. I believe, based upon my experience, my relationship with others, as well as my judicial philosophy, would be a good contribution to the 5th DCA if I were to receive that position. Thank you. Mr. Sasso?
Good morning, Judge. How are you today?
I'm doing well. How are you?
Nice to see you. I read with interest your City of Orlando and Lasercraft decision.
Yes.
How did you like working with the Judges Sawaya and Torpy on that?
I enjoyed it, actually. I had never met Judge Sawaya before, and I found afterwards at lunch, a lot of people joked, I guess, about his personality, somewhat, I suppose, can be somewhat sarcastic or so at times, but he was enjoyable to work with, extremely intelligent. I enjoyed both working with him as well as Torpy, and we all essentially came to the decision after a discussion based upon the circumstances to make the opinion that we did with the preemption, and which I wrote.
I also read your death sentence opinion. It was very lengthy.
Yes.
I'm just curious, how much time did you spend on that?
Oh my gosh. A few weeks, actually. It was, first of all, it was a 3.5-week non-jury evidentiary hearing over a course of a year. So essentially, some of the aspects of that, I had to go back and review all of the transcript, never mind the fact it was my predecessor who originally tried the case. So in my preparation of it, I had to review the entire transcript, and also they entered into evidence and stipulated the actual video, because sometimes the transcript can take out of context certain things, and there were things that were demonstrated, so I watched the videos as well and had to go back and refer to that. So it was something that was 18 or 19 issues and sub-issues, and so in order to go over that, it was definitely quite a few weeks. As far as even the initial preparation was longer, but the actual writing of it and going back and reviewing the transcript again to make sure that it was a appropriate opinion and all the issues were appropriately addressed.
Yeah, well, I get the impression you worked very hard on it.
I did, definitely.
I'll defer.
Well, in the interest of full disclosure, Lasercraft was my client.
Sorry for that.
It happens.
It happens.
There's always that.
That was a very well reasoned thing.
Thank you very much.
You still
You're
like
not the wrong way.
Yeah, I was gonna say.
Sometimes.
Judge, you came before us in March earlier this year,
Yes.
and you addressed some of the commission's prior concerns regarding
Yes.
your driving record, and I was just wondering how that was going. Have you had any stops this year?
No. And essentially, I just want to say, I've never run from any obligation or avoided any circumstance, and I've never used my position or would ever attempt to use my position to my benefit. And so just to, I hope that would show the type of character and person that I am.
You said heavy foot.
Pardon?
You had a heavy foot a couple of times.
Sometimes failing to pay attention, unfortunately, yes.
I have a question for you, if you got a minute here. What do you perceive to be the greatest need of the 5th DCA? And the second part is, what's your plan to address that need?
Well, greatest need necessarily, I do believe there are some judges who have trial court experience. As I indicated, I do believe that can be an advantage of having trial court experience. Essentially, I have the benefit of having the trial court experience that I do, as indicated, that you review the perceived error of trial judges, and I think in that process, sometimes, like I stated, the context in a transcript can be taken out of context, and the ability to have that experience to review that decision makes a difference. Further, the other aspect is to make sure that the circumstance in which, although the court could, at this time, only has one female. And I don't know if it's necessarily a need to have a female. However, I think different walks of life, different advantage perspectives can be provided with different individuals on the 5th DCA. And we only had briefly 2 females for a very short period of time. And then essentially it turned out that we only have one at this time. Although I do believe qualifications and experience can make a difference, and that should be the primary threshold when deciding that issue, it otherwise can be developed and indicated where once that threshold is met, that you do then possibly consider that, and I think that can offer a different perspective and an advantage.
Thank you.
There's been a whole series of cases which have come down recently at the circuit level, the mid-appellate level, and the Supreme Court, wiping out some acts of the legislature which traditionally had the effect of limiting plaintiffs' rights, for instance, workers' compensation, medical malpractice. Do you have a position as to the new wave of opinions that seem to be coming out based on access to the courts and equal protection clause and and basically a comment on the relationship between the rights of the legislature versus the judiciary?
And I'm sorry, because I want to make sure that I heard everything, because I did have a bit of background. Essentially, you're asking as far as the rights of the legislature versus the judiciary and the opportunity on that issue. Well, essentially, they're 2 different branches of government. They're to be indicated differently. The job of the legislature is to make the law, and the job of the judiciary is to follow that or interpret that law. And essentially, the judiciary is to make sure that the letter of the law and the words of the law are to be followed, and to make sure that they're interpreting the aspects of the legislature. I can tell you that I had an opinion that was recently affirmed, or actually I think it was back in March, affirmed by the 5th DCA, in which in that particular instance, I followed the letter of the law of the circumstances and the interpretation of what I believe the legislative intent of the statute was. And in that particular instance, there was, I suppose, an opinion that did somewhat conflict from that, which they receded from, and looking back at the statute and indicated and agreed with me and affirmed that decision regarding the interpretation of that statute. And so I think it's a judge's job to make sure that the letter of the law is being followed, and that the legislature have their job in order to make sure that they are following that law.
Let me ask more specifically, do you think that the courts are overreaching in using access to the court's arguments, equal protection arguments, and all those things to disavow acts of the legislature involving limitation of remedies?
Well, you're asking a generalized question in regards to courts overreaching. I think there may be specific opinions or certain opinions at times that some individuals may believe that, but different courts handle it differently. And I can tell you personally how I handle it. And I believe that the aspect of the legislature is to make sure that they're writing that law, and that in our instance, as a judge, my job is to make sure that that's being followed.
I have a question.
Yes.
When you, the two opinions that you have here, the one for the 5th and then the case involving the sentencing.
Yes.
Motion to vacate the sentence. I'm just curious, because these are, the work of a trial judge is very busy, obviously. You spend your days in court, and when you're not in court, you're reading files. How do you have help either with law clerks or anybody that is on your staff helping you write and edit the opinions and research the opinions, or is this something self-authored where it's 100% you?
Those opinions I personally wrote. Essentially, initially, I can say when you when I went to the 5th DCA, there was cases or a presentation on the issues that was initially researched or done as some research provided by the law clerks. But initially, in both of those opinions, I wrote those. As a matter of fact, there were times with the opinion specifically dealing with the death case. I was in the office till 1 or 2 in the morning working on the opinion. So I personally, those opinions are particularly attached because those are opinions that I had written. I did have, like I stated, I believe initially there was on the initial opinion with Ludachenko, but the opinion itself was, I had written, and as well as the other opinion I had written, which is why I attached those.
Well done.
Thank you.
How do you feel about summary judgments?
I personally believe that.
Believe in affirming them?
Well, I personally believe that summary judgments are to be granted when the law requires. Essentially,
How about up here?
Well,
Affirming them.
and I would agree that if the law requires, then yes, they're to be affirmed. Basically, the purpose of a summary judgment is to refine the issues prior to a jury trial, and also to make sure that you're avoiding any unnecessary costs of litigation. Approximately, I believe it was 3 weeks ago, as a matter of fact, I just granted a summary judgment in favor of an insurance company based upon the issues, was dealing with policy language and interpretation of policy. However, I think 2 weeks before that, there was a summary judgment on a reformation issue where they needed to file a reformation action, and I denied that summary judgment. But I believe the purpose of the summary judgment is to make sure, if the only issue is the law, that then you're avoiding unnecessary costs of litigation if it is to be granted. So yes, I believe in granting them, and then I would hope that if mine is appealed, that I'm affirmed on it, because I believe when the law requires, it should be granted. But again, if the law requires otherwise, that it's not there, then it should be denied. But in the appropriate circumstance, yes.
Okay, because this court has a reputation of they haven't seen a summary judgment they liked.
Well, then I hope that as far as when they see mine, they agree with me entirely.
So when you're a circuit judge, you like to see PC affirms. What about when you're a litigant, appellant?
I-
And you feel there are substantial issues in the case? And I guess my question is, what is your philosophy, or what would be your philosophy on when it is appropriate to PCA a lower court ruling?
When you, well, essentially, there are circumstances, I think even as a trial judge sometimes, but yes, litigants or trial judge, if it's a complex issue that may keep arising in the future, that there may be a necessity to possibly do an opinion in order to provide some guidance for that circumstance. But of course, you can't do a PCA on, an opinion on every single issue. You'd be there forever. And a PCA then is, of course, appropriate in most circumstances because the issues are clear, the issues are there, and it should be affirmed.
Thank you.
I've been told by various judges, and maybe this is just opinions, but that when you're a trial judge, it's more of an extroverted type job where you're dealing a lot with litigants, witnesses, things like that. And then when you come to this type of court, an appellate court, especially this one, a lot of the judges don't live here and aren't here every day. It's more of an introverted type position where you do have some teamwork, but there is a lot more time on your own, where you're thinking about opinions, writing opinions on your own, things like that. What do you think your personality is more like, more introverted, extroverted, and how would you adjust from being a trial judge to here, to this appellate court with your personality?
I'm a combination. We had to do that personality test when we first became a judge, and actually I'm kind of split in between, believe it or not. But I personally, I do enjoy the aspects of the trials as a trial judge, but also as a trial judge, believe it or not, you're doing a lot of the researching and the writing, and I enjoy the challenge of that aspect, and I enjoy that researching. I personally, before I do my docket every day or a couple days beforehand, I prepare and review all the files. I research some of the issues. As a matter of fact, the summary judgment that I granted, I used a case that I cited that neither party ever cited to me in granting the summary judgment. So I enjoy that aspect of the research as well as the writing and the intellectual challenge of it. So you do that as a trial judge. Granted, in the appellate capacity, which I've also served as a circuit judge, you do that as well. And so in that sense, because of that intellectual challenge, I think I would enjoy it very much.
Word to your 2 minutes to close.
Okay, all right. First of all, again, I want to thank you for the opportunity to speak with you all today. As indicated, I know in this process, hopefully you've had the opportunity to get to know me somewhat better and through the vetting process, and I hope that you would find that based upon my personality and my character, as well as my work ethic, that I would be able to contribute highly to the 5th DCA. As well as indicated, my background and experience, my relationship with my fellow members of the judiciary and the camaraderie that I have with them, as well as my judicial philosophy, would be able to be a good contribution to the 5th District Court of Appeals. I enjoy the aspect of the researching and writing and the intellectual challenge of it, and I can say if you would have the wonderful ability to send my name up to the governor, that I would work extremely hard to make sure that you are proud of that decision.
Thank you, Judge.
Thank you.
Thank you.
Thank you.
Can I go back out this way?
Sure. It's the second door.
Okay, thank you.
Thank you.